You would never sign a $1 million business deal on a napkin in a noisy cafe, right? Imagine this. You're in a boardroom. A 10-pound contract sits on the table, and teams of lawyers are scrutinizing every single line. You'd demand to understand every clause, every obligation, and every penalty for failure before your pen ever touched the paper. Yet every single day, people willingly enter into life's biggest and most consequential contract, marriage, without any idea what the terms are. They're signing it blindly, based on nothing more than a feeling and a fairy tale. This isn't about being unromantic. This is about acknowledging the brutal truth about the legal and financial obligations that romance often hides. This is the fine print of your life, and you simply cannot afford to ignore it. We've all been sold a fantasy. From the time we're kids, we're told that marriage is the ultimate expression of love. It's a fairy tale ending, a white dress, a big party, and a promise to be together forever. And while love is absolutely the reason to get married, it's not what marriage is from a legal perspective. Legally speaking, marriage is a binding three-party contract between you, your partner, and the state. That's right. The government is an active party in your union, and it sets the rules. The romance is the marketing campaign. The marriage certificate is the legally binding document that merges your life with another person's, in the eyes of the law. The hard truth is that most people never read this contract. They have no clue what they're agreeing to until it's too late, when the deal breaks down, and they find themselves in a sterile courtroom, watching a judge divide their life based on a set of rules they never knew existed. Studies consistently show that financial problems are a major factor in divorce, contributing to a significant number of them. In fact, couples who argue about finances at least once a week are 30% more likely to get divorced. It's often the financial stress that kills a relationship, not a lack of love. And when it does, the average cost of a contested divorce can range from $15,000 to $30,000, and that's before accounting for the emotional devastation. So today, we're looking at marriage for what it legally is, a business deal. We're going to examine the tough truths hidden in the fine print. This isn't to scare you away from marriage. It's to arm you with the knowledge to make it the best decision of your life, not the one that could destroy it. Truth number 1. It's a financial merger, not a fairy tale. The first and most critical truth you have to accept is this. The moment you say "I do," you are executing a financial merger. From that point on, you and your partner are seen as a single economic unit, in the eyes of the law. Think about what that really means. When two companies merge, they combine everything: assets, debts, revenue, and liabilities. The same goes for marriage. That huge credit card debt your partner has from before you even met, depending on where you live and how you manage your finances, it can become a shared problem that affects your joint ability to get a mortgage or a car loan. The student loans you've been diligently paying off, they're now a line item in your joint financial health. More importantly, the wealth you build during the marriage is typically considered marital property. It doesn't matter if your paycheck is 10 times bigger than your spouse's. It doesn't matter if you were the one who launched a successful business from scratch after you got married. In many states, the default rule is that everything earned or acquired during the marriage, including the appreciation of a business or the funds added to a 401k, is split right down the middle in a divorce. Investor Kevin O'Leary, who has seen countless businesses rise and fall, often says that families are businesses. He argues that the number one reason for marital failure isn't infidelity, it's financial stress. To pretend money isn't a central part of the equation is reckless. This is why you must have brutally honest conversations before this merger. It's called due diligence. What's your partner's credit score? How much debt are they bringing to the table? What are their spending habits? Is there a savings plan, or is it paycheck to paycheck? What is their philosophy on investing? What are the long-term goals for retirement? Who's managing the budget? These aren't romantic questions, they're business questions, and failing to ask them is like buying a company without ever looking at its books. Truth number 2, the state is your default business partner. If you think you don't need to define the terms of your marriage because you trust each other, you are dangerously mistaken. The truth is, you already have a contract. If you don't create your own, the state you live in has a pre-written one for you. It's called Divorce law. When you get married without a prenuptial agreement, you are accepting your state's default prenup. You're agreeing to a one-size-fits-all contract written by legislators and interpreted by judges. Strangers who know nothing about you or the unique circumstances of your relationship. And you probably won't like the terms. These laws differ significantly by state. Most states operate under an equitable distribution system, where a judge divides property fairly, which does not always mean equally. A judge will consider a list of subjective factors, like the length of the marriage, the age and health of each spouse, their income and future earning potential, and even non-financial contributions like being a homemaker. This makes the outcome highly unpredictable. 9 states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin are community property states. In these states, with some exceptions, all assets and debts acquired during the marriage are typically split 50-50. The state's contract also dictates rules around spousal support, or alimony. A judge could decide you have to pay rehabilitative alimony to help your spouse get the education or training needed to re-enter the workforce. Or, in cases of long-term marriages with large income gaps, even open-ended alimony with no fixed end date. The financial split is often determined by a formula, and in many places, it doesn't matter if your partner cheated. Marital misconduct often has no bearing on the financial outcome. By failing to set your own terms, you are letting the state be your senior business partner, and if the deal goes south, that partner gets to call all the shots. Truth number 3, you are putting up collateral. When you take out a business loan, the bank demands collateral, an asset they can seize if you default. It's how they manage their risk. Marriage operates on the same principle. When you sign that contract, you're putting up the most significant collateral imaginable. A claim on your future income, half of your current and future assets, and even your future relationship with your children. Let's be crystal clear about this. The collateral in a marriage contract includes your future earnings. Through mechanisms like alimony, a court can give your ex-spouse a claim on money you haven't even earned yet. For years after the marriage is over, a part of your paycheck could be legally theirs. Your assets, your home, investments, retirement accounts, and even a business you built are on the table. Even assets you owned before the marriage can become marital property if they're commingled. For example, if you get an inheritance, separate property, and deposit it into a joint bank account, those funds are now likely commingled and considered marital property. If you own a home before marriage, but use joint funds to pay the mortgage or for renovations, the house may become a commingled asset. A court may also look at the dissipation of assets, where one spouse wastes marital funds on gambling or an affair, and hold the wasteful spouse accountable during the division of property. While custody isn't a financial asset, it gets tangled up in the financial breakup of a marriage. Custody battles are not only emotionally devastating, but financially ruinous. The division of parenting time often directly impacts child support payments, which can turn the most precious relationship in your life into a point of financial leverage. The romantic side of marriage completely ignores this concept of collateral, but the legal system doesn't. It sees a divorce as the liquidation of a failed partnership. It will tally up the assets and divide them according to its rules, and your personal sacrifices, or your partner's betrayals, often carry very little weight in that final calculation. Truth number 4, a prenup isn't planning for divorce, it's your business plan. There's a massive, misguided stigma around prenuptial agreements. People call them unromantic. They say, if you're already planning for divorce, you shouldn't get married. This is perhaps the most dangerous piece of romantic nonsense out there. A prenup is not just for the wealthy, it's a practical tool for any couple. Let's reframe this. A prenuptial agreement is not a plan to fail. It's the business plan for your marriage. It is the single most effective tool you have to build your financial partnership on a foundation of radical transparency and communication. The process of drafting a prenup forces you to have the most difficult, and therefore most important, conversations before you sign the contract. It makes you put everything on the table. How will you handle existing and future debt? How will property, including future inheritances, be defined and divided? Will you have joint or separate bank accounts? How do you protect a family business or assets for children from a previous marriage? What happens if one partner steps back from their career to raise children? How will they be compensated for that sacrifice? What happens in the event of death? A prenup can work with an estate plan to dictate how assets are handled, overriding state laws about spousal inheritance. A prenup isn't a sign of doubt. It's an act of supreme maturity. It replaces the state's vague, one-size-fits-all contract with a custom agreement that reflects your shared values. To be enforceable, a prenup must be created correctly. This generally means it must be in writing, signed voluntarily without coercion, and include a full and fair disclosure of all assets and debts from both parties. It's highly recommended that each person have their own independent lawyer. Thinking a prenup is unromantic is like thinking a pilot doing a pre-flight safety check is planning to crash the plane. No, they're doing it to ensure a safe and successful journey. Your marriage, the most important journey of your life, deserves its own pre-flight check. Marriage can be a beautiful, life-affirming partnership. It can be a source of incredible strength, joy, and support. But love alone doesn't make a marriage successful. A successful marriage is one where two people walk into it with their eyes wide open, fully aware of all the promises they're making, both the romantic ones whispered at the altar and the legal ones codified by the state. To ignore the contractual nature of marriage is to walk onto a battlefield unarmed. You are giving up control of your financial future to chance and the cold, impersonal machinery of the legal system. The four truths are simple. Marriage is a financial merger. The state is your default partner if you don't define the terms yourself. You're putting up immense collateral that includes your future. And a prenup is the business plan that allows you to navigate all of this with clarity and intention. Understand these truths. Have the hard conversations. Read the contract before you sign it. Build your marriage on a foundation of love and brutal honesty. That's the only way to protect yourself, your assets, and your future, and to ensure the best day of your life doesn't inadvertently lead to the worst years of your life. Signing that marriage license can be the best financial and personal decision you ever make, but only if you go into it with a clear understanding of the agreement. Understand the terms before you sign.